A trust is a legal structure that protects property for someone's benefit. It separates legal ownership from the right to enjoy the property. And in the case of Nicholas v. Eaton, it can even shield assets from bankruptcy. Business law involves two crucial instruments that dictate the distribution of assets after someone's death: wills and trusts. Both are essential for ensuring that property is passed on as the deceased intended.
A trust is an arrangement where the grantor places property under the care of a trustee to manage for the beneficiary. Express trusts are clearly written and intentional. Implied trusts, in contrast, arise by law, often when there's been a misuse of property or unfair benefit. A trustee has serious responsibilities, acting honestly, prudently, and with loyalty to the beneficiary. A spendthrift trust is a trust that lets the beneficiary receive certain assets only if they meet specific conditions.
A will is a legal document that outlines how a person's property should be distributed after death. It can also establish a trust, a tool used to manage and protect assets for others, often for many years to come. To be legally valid, a will must meet several key requirements. First, the person making the will, known as the testator, must be of sound mind and at least 18 years old. In order to pass as sound mind, the testator must be able to list what property they own and who their legal beneficiaries are. They do not have to give their assets to any of these beneficiaries. They only need to know these people exist. The will must be made voluntarily, without pressure or undue influence from others. It must also be in writing and signed by the testators. In most jurisdictions, it must be witnessed by at least two individuals who are not beneficiaries of the will. These witnesses confirm that the testator signed the will willingly and was mentally competent at the time.
In the case of Nicholas v. Eaton, when Sarah B. Eaton died, she left behind a detailed will. It created an express trust, transferring all her property to 3 trustees. Her instructions were clear. The income from the trust, rent, interest, and dividends, was to be paid equally to her 4 children during their lifetimes. After their deaths, that income would go to their children if they reached the age of 21 or died younger, leaving children of their own.
The spendthrift clause was put into the will to protect the inheritance from creditors, poor financial decisions, and outside influence. Mrs. Eaton wanted to ensure that the trust would serve as a stable, secure source of income for her descendants, rather than becoming a liability or a bargaining chip in times of financial distress. By making the trust inaccessible in cases of attempted transfer or bankruptcy, she created a safeguard that prioritized the long-term welfare of the family over short-term gain or mismanagement. This way, even if one of her children fell into financial trouble or made questionable decisions, the trust would still serve its original purpose, providing for the family and preserving the wealth across generations.
A few years after his mother's death, Amasa M. Eaton, one of her sons, failed in business. He assigned his property to Charles Nichols for the benefit of creditors and was declared bankrupt soon after. Because he had no wife or children, his right to the trust income was forfeited, and no one could claim it on his behalf, leaving his portion of the trust untouchable until his death or marriage. In case of his death, his money would be divided out to his siblings.
Upon this knowledge, Charles Nichols, the assignee responsible for managing Amasa Eaton's bankruptcy estate, filed a lawsuit in an attempt to claim access to Amasa's portion of the trust. Nichols believed that the trust's income, rather than being indefinitely protected, should be distributed to satisfy outstanding debts owed to creditors, including himself. He argued that it was unjust for Amasa to benefit from a consistent income while his lenders received nothing, especially considering the substantial debts left unpaid during the bankruptcy process. Nichols based his legal argument on a specific clause within Miss Eaton's will, which stated that the trustees had the discretionary authority to give up to 1/2 of Amasa's annual income shared directly to him. Nichols claimed that this provision effectively opened a door for creditors to step in and claim those funds. In his view, since the trustees were empowered to make direct payments to Amasa, those funds could be intercepted and redirected to pay creditors without violating the spendthrift clause. He contended that this clause conflicted with the intent of the spendthrift provision and weaken the overall protection of the trust. In his lawsuit, Nichols also pointed to broader principles of equity, asserting that it would be morally and legally unfair to allow Amasa to continue receiving benefits from the trust while leaving his financial obligations unmet. The case ultimately raised complex legal questions about the limits of spendthrift trusts, the authority of trustees, and the rights of creditors in bankruptcy proceedings. It tested whether a settler's intention to protect beneficiaries from financial ruin could override the interests of those to whom the beneficiary was lawfully indebted.
But the court disagreed. The clause was discretionary. The trustees could, but were not required to transfer funds. There was no obligation and thus no legal right the creditors could enforce. The spendthrift provision held strong. Amasa's income was protected, not for him, but from him. Justice Miller, writing for the majority, explained that a person has the right to leave their property with conditions that limit how it's used even after death. If the trust was created to support the son while protecting the assets from its creditors, the law would respect that intent.
Nichols v. Eaton became a landmark in American trust law. It confirmed that spendthrift clauses are enforceable and that trustees with discretion cannot be forced to act, especially not by creditors. The case remains a foundational precedent for asset protection and estate planning today. The lesson is simple yet profound. A well-crafted trust, built with careful foresight and thoughtful legal design, can endure through the most challenging circumstances, including personal bankruptcy, family disputes, unforeseen financial crises, and even the death of its beneficiaries. Such a trust acts as a financial shield, preserving wealth and honoring the wishes of the individual who created it, often long after they are gone.